I rise to lend support to the bill currently before this Honorable House, the National Assembly Elections Amendment Bill 2020. And to say, Mr. Speaker, that as this administration, the Team Unity administration, embarks on its second term in office, that we are committed to ensure that our democracy is alive and well, that our laws are in order, and that the rights of our individual citizens are upheld. The idea of electoral reform has been one that is exceptionally significant and has been around for quite some time. And if we were to look at the 37 years of our independence, we would note the evolution of the current Parent Act that would have been first passed back in 1983. It is, of course, a continuation of other legislation that goes all the way back to 1952, when universal adult suffrage first came to this country. And universal adult suffrage, as an explanation, means that all citizens who qualify by basic terms and conditions have a right to exercise their franchise. It does not mean that before 1952 that there were not elections, or that there was not a system of voting, but that was somewhat restricted. And those who voted could only do so if they qualified through property ownership or received salaries and wages in excess of a certain amount. So that the vast majority of people in our country would have been excluded from being able to vote. The Legislative Council, as it was then, would have had a mix of ex-officio officials that came as part of our colonial status and who were automatically a part of the executive and of the council that made laws, and the LegCo would also have had members of our community who would have been considered to be assisting in the governance and the management of our country. But in 1952, following the general movement that would have been initiated in the 1930s by the Workers' League, and we would have learned of the Buckley's riots, the 1930s, the presence of the Moyne Commission that would have come in 1938 to look at the conditions of life in our country, where many of our people lived in the substandard conditions. Recommendations of the Moyne Commission and others would have led to a gradual and initial movement to try and better the lives of our people. And when in 1952 we had our first government that would have been elected, in the House of Assembly, albeit in a colonial status at the time, we would have begun that long movement to where we are today in terms of the process of developing our laws, or developing our practices, and so forth. The National Assembly Elections Act is an important one, Mr. Speaker, in that regard. And the amendment made today, as the Honourable Mover of the Bill, the Honourable Prime Minister, Member for Number 7, had said, is a first step under this administration. We will be coming back to this Honourable House over the next weeks, months, term, to constantly try and improve it. Because there have been a number of areas where the bill, the act, has not been right. The conduct of elections have been observed by organizations in which we have an important relationship, the Commonwealth, the Organization of American States, CARICOM. And they have sent observer missions, as has reproduced local observer teams. And over the years, these different missions have indicated that whereas for the most part our elections were conducted in a free and fair manner, for the most part our people had exercised their franchise, that there were areas where we could improve. We have heard of such things as campaign finance that need to be looked at. We have heard of other issues. We ourselves become frustrated and uncomfortable with the length of time the counts have been had in recent elections to announce winners in various constituencies. And of course, we remember in 2015 the debacle in which we did not even announce winners in certain constituencies, certain seats, and that was problematic. What we do today has to deal with voter registration. Voter registration is at the heart of any electoral system. Who is able to vote? Who qualifies to vote? And that is what this bill is, the first step. We have a number of people here in our country, we can refer to them as both citizens and residents. They're all residents. But all residents do not have a right, a constitutional right or any right, to feel that they must vote, to feel that they have to be registered to vote. And this starts with our Constitution, because in section 29 of the Constitution of St. Kitts and Nevis, it speaks to the election of a representative, and in subsection 2 it says this: every Commonwealth citizen of the age of 18 years or upwards who possesses such qualifications relating to residence or domicile in St. Christopher and Nevis, and here comes the part, as Parliament may prescribe, as we are doing today, shall, unless he is disqualified by Parliament from registration as such, be entitled to be registered as a voter for the purpose of electing representatives in one, but not more than one, constituency, in accordance with the provisions of any law in that behalf, and no other person may be registered as such. So, Mr. Speaker, the pool of people who can register to vote in our elections are Commonwealth citizens. If you're not a Commonwealth citizen, you're not entitled, you're not qualified to vote as the law stands today. All Kitchishans and Divisions are Commonwealth citizens by nature of being citizens of St. Kitts and Nevis, so they're automatically qualified. Who are the other Commonwealth citizens who qualify? And those are members of countries that were part of the British involvement around the world, where they went and they established themselves in countries in Africa, in Asia, in North America, in the Caribbean and elsewhere, in the Pacific. And part of that colonial, as it was then, relationship, and as countries became independent and graduated, as it was, into other status, we then formed the organization, the British Commonwealth, of which Queen Elizabeth is regarded as the head of that organization. The Commonwealth then is based in a colonial status. It has to do with the fact that we are former British colonies. Some of our neighbors in the Caribbean have moved away from that Commonwealth status. It doesn't mean that they don't have relations with Britain or anything of that nature, but they may want to change that relationship. But some of these countries in the Commonwealth, as we become independent, are far-flung and have no other connection with us. For instance, Tonga,
yes.
Fiji, where are they? Anybody ever hear about Vanuatu?
Yes.
You know, Vanuatu, it's a nice name, but where is it? You know, somewhere far-flung. They have nothing to do with us.
Yes.
And they can come here on our current arrangement and spend 12 months, and they have a right, according to our constitution and law, to be registered to vote. But everybody in St. Kitts and Nevis now where Santo Domingo is, they can't come here for 12 months and register to vote. They do not have the right under our constitution. Haiti, who is part of CARICOM, does not have that right. These are people, our neighbors in the Caribbean, who we have gone there, had children and come back. Those are citizens, and let's avoid.
Be careful.
But the point is, there is a distinction when we speak of Commonwealth.
Yes, there is.
In our relationships.
And it's real.
You know?
Self-evident.
From the 1970s, from the late 60s and 1970s, St. Kitts and Nevis, along with other states in the OECS, today's OECS, would have become an associated state with Great Britain and shifted up, moved away a bit. And then we were part of the wider English-speaking British legacy and became part of CARIFTA, the Caribbean Free Trade Association. And that is our evolution. And then became the Treaty of Bastille, right here in St. Kitts, where OECS states signed, as it was, to free movement in our islands. St. Lucia, Grenada. They come here for 6 months and they don't need to show the passport and all that. It's an extension. That's free movement. We are also signatory to the Treaty of Chaguaramas, which is a town in northeastern or northwestern Trinidad that formed CARICOM, Caribbean Community, that gives us free movement of people, trade, free trade in goods and services. These are people who we relate to.
Yes.
And think about it. Britain, who we have had that historical relationship, they have been part of the European Union that had the same freedom of movement, free movement of goods and services. In essence, Britain was closer to our European neighbors than she was to us after a while. And so there is a distinction in terms of who we think and who we have an affinity to be a part of our mix here in St. Kitts and Nevis. Again, the Constitution is clear. All Commonwealth citizens, once they live here for 12 months, or once they are here, all Commonwealth citizens, the Constitution will say how long, can be registered to vote. So we can't tell them no. What it does say in the Constitution, Parliament can prescribe how long and how they can be qualified. And so the simple bill we do today, the simple step, is to say that there should be a distinction between our Caribbean Commonwealth neighbors and those who are in far-flung reaches of this world who don't have that connection with us, who maybe after 12 months, 16 months, they pick up and go, but they could say what government they want here.
Yes.
And so this is a small step, but a first step in qualification. We said that our CARICOM, our Caribbean Commonwealth neighbors should continue to get qualification once they live here after 12 months. And I interject at this point the concept of residence. When they reside here, the resident in St. Kitts and Nevis. And the concept of residence is an important concept. We say that if you come from an African nation or Asian nation and other climes, that you should spend a little longer to show that you have become acclimatized to us here in the Caribbean and to our people, and you understand our culture, our mores, our laws, our what we do. And we say 3 years is what we recommend. Mr. Speaker, I'd also want to suggest that at some point in time, our people will have to address the idea of other residents. And if they, many of them own businesses, many of them make contributions to our country in a number of ways. And I've been here for many years. And if they're resident in our country, how do we get them to have certain responsibilities and obligations? And should we consider that they too should? You note, Mr. Speaker, that on the order paper for first reading today is an amendment as well in terms of citizenship. that those non-Commonwealth people can become citizens. We will come back and debate that. We'll debate how long they should reside here. At the moment, if somebody wants to be a citizen, they have to be here for 14 years. 14 years. We are the only Commonwealth Caribbean country that has such an extensive period of time. Others of them, and only for Commonwealth. Okay? Most others, if not all others, at least 7 years. Some are 5 years. And so, an alternative to those who may not be non-Commonwealth can be satisfied through this citizenship process. If you're really committed to St. Kitts and Nevis, you love it here, you have been here X number of years, and want to participate fully, you become a citizen. And so you could also register to vote. So the concept is qualification in terms of residence of those who come from outside to live with us. Mr. Speaker, it's a very simple bill. So that is the first part of the bill. The second part of the bill, Mr. Speaker, speaks again to a concept of residence. That if I live in Molyneux, I should register to vote in Molyneux and not seek to want to go in challengers to unseat Lindsey Grant. That don't make no sense. I reside in Molyneux and I should register to vote where I live. It's a principle of the National Assembly Elections Act that speaks to the concept of residence. Let us not get away from it. We have to register where we live. And I hear a concept that if I have 5 boyfriends in different parts of the country, I could decide which one of them I want to register with. You live somewhere. I don't know people got 5 boyfriends that got 5 residences. If you reside somewhere, you live somewhere, it can be established, you know where you live. Some of us, of course, have apartments in Frigate Bay or on Ford Street or in other areas around the country. But we know where we're from and where we live. We know where we live. Residents. You must register to vote. You must register to vote where you live. You know where you live?
You know where you live. Others know where they live.
Oh, I see.
You can't determine.
I can't determine that. Well, I must say, Mr. Speaker, I'm glad that the leader of the opposition has raised this, because this has been, we have been talking about this, talking about this for 25 years. 25 years this has been going back and forth. And let's put it on the table.
The law allows you for that.
Let us put it on the table. The law allows you for that. The law allows for that. But we can manipulate the law.
No.
And we know that for a lot of years, that in areas where the Labour Party has felt they are not as strong as in other areas.
What this law in the first instance?
It doesn't matter who bring it. You know what I mean? It is what it is. If the law is flawed, it needs improving and correcting. It needs changing.
All of a sudden you said the Labour Party?
But I'm talking about that because there was a policy that if it is, I can register you somewhere else and it can't be found out. Fine. And the idea is that to make our democracy proper and requisite, that we should adhere to the basic principle. If I live in Greenlands and my roads are not being fixed, and I have problems with my electricity and water, or my daughter wants help, I should be able to go to my representative for that area, who knows me, knows of my problems, for assistance. That's what representative democracy is about. That those who live in a particular area should be able to approach their representative to make representation to public services and other types of things for their assistance. Sometimes we go by the pastor, sometimes we get a teacher, but the elected representative, his or her responsibility is to see what the constituents who ostensibly vote for you require, and you respond to them by making representation on their behalf. That's representative democracy. And I can see how if I live in Challengers and somebody live in Molyneux, because the mother live in Challengers next to me, they could come and decide who should represent me in Challengers. It is about representative democracy. You register where you reside. I think that's a very simple concept. What is ordinary residence? Yeah? And that is defined in the law. And not just the law, the statute. Because this has gone to the court, the High Court. It has gone to the Court of Appeal and has been interpreted in our courts, Mr. Speaker. There's a case of Lauren James and Dudley Williams that has gone all the way up to the Supreme Court, where Court of Appeal Justice Barrow, as he was then, was very clear. It is not sufficient to say, I know that that individual does not live here, but I know them, and I know where they live, over there. And the court has said, if that's the case, that person should not be on the register here. They should be removed. That is the law of the land. That is the common law, interpreted by the Court of Appeal. And there is a procedure for these things in the National Assembly Elections Act. When somebody registers to vote, Mr. Speaker, and they do so in a calendar month, October, any day in October, the law provides in section, I think it's 43, that the following month, the 15th of the subsequent month, so the 15th of November, a list of all those who registered for this constituency should be published in a public place inside that constituency, that polling division. That is the law. There are provisions within the law, as section 35, I think it is, to allow 35, to allow each political party to appoint scrutineers Each political party shall be entitled to nominate, in accordance with the prescribed form, one person who is qualified as a voter for appointment as scrutineer in respect of each polling division, and the person so nominated shall be appointed accordingly by the registration officer for the constituency in which a polling division is situated. And the scrutineers attend at the office every month. A lot of them don't, but there are agents who go to that office to collect the list, to scrutinize it. Does this person really live in this polling division, in this constituency? Or is it the visiting the boyfriend and want to register? I think what it was, MRI, multiple relationship individuals, was the phrase I heard today. First time I hear that. First time I hear that, yeah.
Oh, it's not only medical, it's social.
It's social as well. I'm sorry, but I learn something new every day. Multiple relationship individuals.
Actually,
You would that one too,
yeah,
Mr. Speaker?
I couldn't remember what I was for.
Yeah, multiple relationship individuals.
I was, you Mr. Speaker.
You know?
Individual, yes.
And the issue really was that because I deal with a lot of men, I could find one of them to register with. Something wrong with that.
That's not what
Must
she
be
said.
wrong.
That's not
That's what I didn't say. Anybody said that.
Yeah.
what
Very wrong.
But you have multiple relationships. You got multiple relationships. And I should be able to choose where I want to register. That's what was said.
It's a ridiculous one.
You know what I mean?
It's ridiculous.
And you could register to reside you can register where you do not reside.
Yeah.
Something can be wrong with that.
Must be.
That is why people have been clamoring for electoral reform.
Yes.
That's what I mean by electoral reform.
The manipulation.
Register where you vote, where you live to vote. Don't move up and down.
Simple principle.
Simple principle.
Yes.
Let me move 10, 20 people so I get an unfair advantage here to pick somebody who the people don't want in that constituency. Something wrong.
That's why you are doing a lot in the selection, yeah?
You're there for 20-something years, you know.
That's why you did that.
You understand that?
You are so bored, you don't boasting about it here today.
But you went up in Bronx in 95 and said that. You said that up in the Bronx in 1995.
Yes, it's
That's what you say.
I said,
If people from up there could come and register and vote and go back, why don't people in St. Kitts can't vote anywhere they want? You understand?
the law allows for that.
When we say we want to tighten the law,
You changing the law.
we want to tighten it up. People must register where they reside. That is the concept. And so therefore, the second part of this simple bill, Mr. Speaker, is to look at this concept of if you had to change your residence. So in other words, I live in Greenlands. I'm properly registered in Greenlands. I've lived there. I work there. I play cricket, football. I there. My neighbors know me. But then I move to Bird Rock or Frigate Bay or camps. Do I keep going back to Greenlands to register to vote? If I move out of the constituency, do I keep going back and keep going back and keep going back? All I now live in a new constituency. The principle is the same.
Yeah.
You need to register where you reside.
Yes.
And we call upon all citizens to voluntarily do so. It doesn't need anything about penalizing you. If we are proper citizens, we understand the concept.
Yes.
And we voluntarily. Don't have to wait for no election. Move and apply that my name transferred to where I now live. And you want to come with the day after, a day before. The principle is what it is. And as law-abiding citizens, we should do what is right. We should follow the rule and do what is right. That's what this is. So, the law provides, Mr. Speaker, common law had provided for, that if you move, you shall remain qualified until you qualify for another constituency. But you don't say how you should qualify the other thing. This is the opposition is right. So, I use the law as it is, as the leader of the opposition said. And I don't have to move. Don't have to move. I keep going back. We say, or we are hoping to say, that after 6 months is an adequate time to consider going and visiting the electoral office and apply to move your name, so that people register to vote where they live. That is the principle. A very simple principle. The mechanics will work itself out in objection hearings and so forth. You know, Mr. Speaker, today, His Lordship, Justice Ward, handed down a judgment. That is important because the senator opposite spoke in a presentation, interjected quite a number of times about COVID. State of emergency in place because of COVID. Dangerous pandemic.
Yes.
And the government trying its best to protect the people.
Yes.
They pass regulations, a lot of regulations.
Yes.
Tight, and you relax them. So we have people adjust to different types of behavior. And over time, we understand that the wearing of a mask is important
Yes.
to protect ourselves. We don't have it, maybe. So we're not wanting to give it to anybody else. But you don't know who you're going to put upon when you walk down the street.
True.
Who going to breathe in your face. And they got it. They might not even know they got it. So wearing of mask is for your own protection and that of your family. And it has been put into regulations to help us adjust to behaviors. Today, and other non-pharmaceutical protocols were put into regulations to help our country cope with this pandemic that is causing havoc in some of the other places in this world. But I want to make the point, the way I talk about that in passing, is to say that this case was filed or served on the governing authorities on nomination day. Not before the dissolution of Parliament or anything like that. So that if it was not proper, something we could have in Parliament. But when it was nomination day, filed it to say something wrong with the state of emergency. That somehow, sorry to call his name in this way, Timothy Harris trying a smart thing. The member for number 7.
And he's here to the
Yeah. He wanted to use state of emergency to beat Douglas again. Eh? He beat you once, he beat you twice, man. He beat you twice. You know? He beat you again. And he's trying a smartness with the state of emergency. And somehow, the police unfair to the Labour Party. Well, the judge has put that to rest today.
Yes.
Put that to rest today.
Rejected it.
The state of emergency was proper.
Yes, it was.
But why raise it, Mr. Speaker? Two other claims, were filed at the same time. The day before election. The day before the election day. We had to go to court to answer to two other claims. It happened so that the people didn't even understand it. They went slip, whoop, whoop, whoop. One of them was brought, I take it by supporters of the Labour Party, 2 supporters, who say they want to put on 184 names on the register of constitution number 4. That's it there before, you know. To vote in constitution number 4. 184 names. Voter registration. Voter registration. There's something wrong with the voters list. All these years, all these years, as I said, that it popped in my head, why now? We washing and urgency.
Well, you know, you have the principle.
But that was last minute. That was last minute. That they want the judge to put on 184 names on the list. And there is concern about the voter registration process. And the claim was that some people may not have gotten notice. They may have gotten notice and pretend they didn't get and don't turn up. And when a hearing is held to hear the facts of whether I live with my boyfriend or my mother, or I live in Molyneux or Challengers, they don't turn up. And so therefore what happens? A manipulation of the voters register. This is what electoral reform is, you know, to try our best to put in place ways in which we can get all of us to be honest and do the right thing. Do the honest and right thing to register to vote where we live. And not go where we feel we could help somebody by padding the list somewhere else. That is what the first step is. And we're going to keep coming back to it, because we think we should get it right.
Yes.
Register to vote where you live. And so, we say, I should just mention, Mr. Speaker, that that claim didn't go anywhere. It didn't go anywhere. There is and has been an issue, because I remember it. I was involved in the matter many years ago. We have 115 people we had to take to an objection hearing. Same old road. Anyway, I won't go into that. But that was a question of service. If I say, I live in Durant Avenue, I live in Durant Avenue, 50 people live in Durant Avenue, and the PAM agents decide, I don't know these people, so they object to the registration officer, who establishes within 10 days of the publication of the list, on the 15th of November, you have until the 24th of November to object to somebody who should not be there. If I'm in Challengers and I know somebody who live in Molyneux, register to vote in Challengers, and I see the publication come out, I have 10 days to say, you don't live here, so I object to you. And the registration officer will then send a notice by registered mail to Challengers. And guess what? In Challengers, nobody knows who names up, because you really live in Molyneux. And so it's returned back to the office. They don't get notice, so they don't turn up.
I see how Challengers and Molyneux came in now.
Do you understand?
Yes, it's a scheme.
You understand? And that happens. So that if we don't get notice, what happened? And so, what we have had to do for the last 2-3 years is that we get the High Court bailiff, the bailiffs, to serve the people in Molyneux where they really live.
We don't get trouble over there.
You don't get no trouble over there. Okay? But that's really the issue. That the system, the law, has to work properly, and we have to find mechanisms to do it. Make sure that you get served and you turn up for the objection hearing with a registration officer. And what the registration officers must do is, if the evidence is there, and I say evidence, let me explain what I mean by that. So you get served. So, I mean, going. Because if I don't tell them, you can't have the hearing. But the bailiff come and file an affidavit to say, I served so-and-so on such and such a date, at such and such a time, and such and such a place. So they get it and gives that to the registration officer. So they can't say they ain't get served. And at the hearing, evidence is presented by a neighbor in Molyneux who, yes, people than you. They know what time in the morning to catch a bus to go to work up Jarrow. They know who your brother and sister be and who your mother be. They know your details. All it needs is get 2 or 3 people to give you an affidavit, short affidavit, 1 page. I know so-and-so, and who are prepared to come to the hearing. So there's evidence that you live in Molyneux. You get evidence that you don't live in Challengers too. So you can't say because my boyfriend lived there, that's where you live. You register to vote where you live. Residence. And the idea is that after 2 years I build a house and I move, and 3 years, or after 10 years, I like Timothy Harris, so I'm going back and vote in Tabernacle every time. That ain't right. You got to go where you now live. Move your name. And we say 6 months. Should be the start. I don't think you have registration officers going on peeping in every window to see if you're there 6 months. Because the common law is that after that first monthly list, that time frame has passed. You can't go 2 months later and say, oh, I find it. But, and here's a good one. The law provides that once a year, the 31st of January, every year, an annual register is printed. And that annual register is the defining register for voting in our country. And any voter in a constituency can object to someone who is on that list. A voter who had made an application and is properly supposed to be on the list can also claim at an objection hearing. So it's not just to take off people or to solve people that who register with a live, but if you register properly, and I should be on the list, who take off my name? My name's supposed to be on the register. My name's supposed to be on the register, so I can make that claim. Now hear the note. If there's a hearing and a decision is made one way or the other, the registration officer must also inform the individual that there was a hearing on such and such a date. You were informed by service by the registration officer. You did not attend, but there was evidence laid in your absence. And I'm notifying you that we believe that evidence and we will take your name off the register for that constituency. The law provides that when you get that notice served on you again, when you get that notice served on you again, you have 7 days where you can appeal to a judge at the court. So you think that they just come off and you can't do nothing. You just can't do nothing. The law provides for you, Section 52 if I'm not mistaken, that you can appeal to a judge in chambers, in the court, to review your case. So it works both ways. If the registration officer decides, by me taking him off, whether he live there or not, the objector can appeal to the court. If you have a valid claim and your name come off, you can appeal to the judge too, in the same way. So there is protection in the legislation. Section 52, appeal. Appeal shall lie to a judge of the High Court, sitting in chambers, from any decision of a registration officer on any claim or objection which has been considered by him or her under this Act. Provided, however, that no appeal shall lie where claimant or objector has not availed himself or herself of his or her opportunity as provided by this Act of being heard by the registration officer on the claim or objection. So you don't turn up to the hearing. You don't do anything, but you're an appeal. Of course, if you have not been publicly served notice, you do have a case, and a judge will hear you. And I can go on. But there is a regime. All we are doing to them, Mr. Speaker, is to begin a process of strengthening this process that's there. It will be happening over the next few weeks, months, and years as we go forward. And we start early. Not in the last shower rain before the election, a day before election day and those type of things. We're giving everybody time to understand what the process is, to make representation, to call in, to meet your representative and question it. So we start now. And there are other things too that we hope that people who have a feeling this ain't right, that talk up about it, because we have to move forward in terms of fixing our system, that everyone could feel confident that we do the right thing. Mr. Speaker, before I sit down, I just want to make one last comment, and that has to do with the concept of boundary changes. Because the concept, the idea of boundaries is part of our whole electoral process too. And this for the last 10 years, 11 years, has been a sore point for many Kittichans. We understand that there are constituencies that are just too large compared to others. And boundaries in our constitution and law is somewhat different from the electoral system. In the boundaries discussion and work, we speak about inhabitants. We talk only about people who live in a particular area. So that to fix a boundary is about where you reside. We look at the number of people in this constituency as opposed to the number of people in another constituency. That includes children who can't vote. Those under 18 are counted as well. So across the board, a constitution should be near equal. That's what the Constitution says. In Schedule 2 to the Constitution, there are a set of rules that indicate how boundaries should be delimited, is the word they use, but divided. Rules for delimitation of constituencies, Schedule 2, and this comes from Section 50 of the Constitution. All constituencies shall contain as nearly equal numbers of inhabitants, as appears to the Constituency Boundaries Commission to be reasonably practicable, but the Commission may depart from this rule to such extent as it considers expedient to take account of the following factors. That is to say, Rule 1 of the first part of that speaks to the fact that if there is to be an increase in the number of seats currently delimited, 18 St. Kitts and 3 in Nevis, that any new arrangement must guarantee that Nevis has 1/3 of the number of seats. So that if you want to put one more seat in St. Kitts, that's 9. Nevis only have 3. Nevis only have a quarter, not a third. So before you could give 1 in St. Kitts, you must increase in Nevis. 4 in Nevis and 9 in St. Kitts is still less than 1/4, than 1/3. Oh, more than 1/3. That is less. Okay? Leave that part. So, it was an important point in terms of the numbers. We also speak about the need to ensure adequate representation of sparsely populated rural areas, means of communicating geographic features like hills and guts and so on, and existing boundaries, parishes, and so forth. I raise that, Mr. Speaker, to state in this Honourable House that the Governor General has appointed a Boundaries Commission in which, in his own deliberate judgment, or on advice of the Prime Minister, having consulted the Leader of the Opposition, he has appointed licensed land surveyor, Mr. James Buchanan, to be chairman of the Boundaries Commission. The Honourable Prime Minister has appointed the Honourable Sean Richards, member for number 5, and member for number 3, the Honourable Akila Byron Nisbet, from the government benches, and the Leader of the Opposition has advised the Governor General to appoint himself and the Honourable Jeffrey Nisbet, Dr. Jeffrey Hanley, sorry, my apologies, member for Constituency number 1, to be on the Commission. The Commission has met. The Commission has met and has had 2 meetings to date, but it is working. It has begun working. And we hope to, in this term, to fix this boundary debacle properly. We have serious problems. In constituency number 8, Keon St. Peters, the inhabitants are approximately 7,400 people. 7,400. Constituency number 5, Sandy Point, Victory, is about 2,600. We have that type of anomaly as well in St. John's in Nevis and other constituencies, St. Paul's or St. George would be a good example. So there is a need for us to do that type of reform. And although it's about the Boundaries Commission, it is rightly considered to be part of an electoral reform process. This administration would hope that over the next months that there will be a proper delineation of the boundaries so that very early, long before we get close to the next election, without any urgency, no mad rush, doing it properly in terms of proper consultation, proper data, and all the other things that should make us be proud to know that our democracy is live and well, that would happen. Mr. Speaker, I want to take my seat, but I want to commend this bill to this Honourable House. It's a short bill, simple bill, but, Mr. Speaker, I was a little taken aback by the presentation made earlier, but I hope I have explained some of them, that people must register to vote where they live, where they reside. And with that, Mr. Speaker, those few words, I commend the bill. May it please you, Mr. Speaker.